Welcome to Immigration Quicktake. This is Ellie Rutledge with the American Immigration Lawyers Association. This week, two decisions were handed down regarding deferred action. One case, Crane v. Johnson, is about the original 2012 DACA program. The other case, Texas v. United States, is about the 2014 deferred action programs, expanded DACA and DAPA. Here to discuss these decisions and provide updates is Patrick Taurel, American Immigration Council's DACA Legal Services Fellow. Patrick, thanks for joining me. Can you walk us through these two rulings?
I think the most important thing for AILA members to know is that these two rulings don't really change the status quo in any kind of meaningful way. People can continue to apply for original 2012 DACA and request renewal of DACA. And the injunction blocking the implementation of expanded DACA and DAPA, which are the programs that were announced in November of 2014, that preliminary injunction is still in place. So more specifically, Crane versus Johnson is the case that's challenging the original 2012 DACA program. And what happened this week is that the Fifth Circuit Court of Appeals basically dismissed unanimously on standing grounds the plaintiff's claim. And the plaintiffs in that case is the state of Mississippi and some disgruntled ICE officers. And so they affirmed the district court's decision, and original 2012 DACA sort of is unimpeded. The other case that was handed down is Texas versus a decision in Texas versus United States, and that's the case that's brought by 26 states, including Texas, that's trying to challenge expanded DACA and DAPA. You probably remember that about 2 months ago, a district court issued a relatively stunning nationwide injunction blocking implementation of both of those programs. And what happened earlier this week is that same district court basically refused to lift the injunction that very same district court had imposed 2 months ago.
Thanks, Patrick. What makes the Crane decision important?
The press has been gravitating more towards the Texas decision, and I think that's probably because expanded DACA and DAPA are likely to affect more people than the existing DACA program, and probably because of some of the salacious thing that the judge that's deciding the Texas case has said about the government and about those deferred action programs. But really the more important case here is the Crane case. And not only did it correctly dismiss the lawsuit, but in addition to that, it signals how the Fifth Circuit may rule in the Texas lawsuit, which is pending before the very same court. So it's precedent that they're going to be bound to follow. And I think it's good precedent for a couple of reasons. One is, it teaches the district court how to conduct the standing analysis in a case like this, and it says that it needs to be an especially rigorous analysis that takes into account not just the costs to the state of a deferred action program like DACA, but also the benefits. Secondly, one of the issues in the Texas litigation is whether or not the program is really sort of case-by-case adjudication. And the court here made clear that these programs in fact call for case-by-case adjudication, which is something that all of you as AILA members know because you've represented individuals, some of whom may have received denials, even though they kind of technically met all of the eligibility guidelines of the program. And then third, the decision just has some good language about the wide sort of berth that our system, our structure of government actually gives to the president when it comes to prosecutorial discretion programs in the immigration context. So I think the Crane case bodes well for the Texas lawsuit, which is going to be before the Fifth Circuit again very soon.
What should we expect to see next for these cases?
So next week at the Fifth Circuit Court of Appeals, the court is going to hear oral argument in the Texas case on the emergency stay request that was filed by the government last month. And hopefully we'll get a decision on that sometime in May. So that means that we can see whether or not this preliminary injunction is going to be lifted and whether the government's going to be able to implement expanded DACA and DAPA sometime close to its original timetable. The case, meanwhile, the Texas case, meanwhile, proceeds in district court toward, in the underlying case, but we do not have a timeline for that at this point in time. Then in the Crane case, it's still unclear at this point whether or not the plaintiffs are going to be appealing continuing to appeal the case.
Thanks, Patrick, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.